Terms implied at common law refers to where the courts imply terms into a contract, where the term hasn't been expressly agreed between the parties and has not been implied by statute. The courts are reluctant to imply terms into a contract at common law. It is the parties' role to agree the terms of their particular agreement. It is generally not considered to be the role of the courts to rewrite a contract for the parties. Freedom of contract prevails. There are limited circumstances where the courts will imply a term into a contract at common law. 1. Terms implied through custom. 2. Terms implied in fact. And 3. Terms implied at law. Where a particular term is prevalent in a trade, the courts may imply a term in a contract of the same type in that trade. This was seen in Hutton v. Warren, 1836. The claimant was a farmer who had a tenancy on the defendant's fields. The claimant had planted corn and barley and worked the fields to ensure the crops would grow. Before the field was due to be harvested, the tenancy was terminated. The claimant then submitted a bill to the defendant for the work and cost of seed, as was customary in farming tenancies. The defendant refused to pay, stating there was no provision for compensation in the tenancy agreement. The court implied a term into the tenancy providing for compensation for the work and expenses undertaken in growing the crops. The term was implied as it was common practice for farming tenancies to contain such a clause. 2. Terms implied in fact. Terms implied in fact are based on the imputed intention of the parties. Two tests have developed: I. The business efficacy test, E. The officious bystander test. The business efficacy test seeks to ascertain whether the term was necessary to give the contract business efficacy. That is, would the contract make business sense without it? The courts will only imply a term where it is necessary to do so. This was established in the Moorcock, where the claimant moored his ship in the defendant's wharf on the River Thames. The River Thames is a tidal river, and when the tide went out, the ship was damaged by the rocks on the riverbed. The court implied a term that the riverbed would be safe for the mooring, as it would not make business sense to provide a mooring that damaged the ship. The officious bystander test was established in Sherlaw v. Southern Foundries. It asks the question, if an officious bystander had been present at the time the contract was made, and suggested that such a term should be included, it must be obvious that both parties would have agreed to it. The courts may imply a term in law in contracts of a defined type. For example, landlord, tenant, retailer, customer, where the law generally offers some protection to the weaker party. In Liverpool City Council v. Irwin, 1977, Liverpool City Council owned a block of flats in which the defendant was a tenant. The common parts of the flats, the lifts, staircases, rubbish chutes, etc., had fallen into disrepair. The tenancy agreement did not mention any obligation to repair. The defendant asked the court to imply a term that the council had an obligation to repair the common parts of the block of flats. The House of Lords did imply a term. The implied term arose as a legal incident in contracts of a defined type between landlord and tenant, that the landlord was to take reasonable care to maintain the common parts. In addition to being a contract of a defined type, the term must be a reasonable one to include. This was established in Wilson v. Best Travel, 1993, where the claimant was injured when he fell through some glass patio doors whilst on holiday in Greece. The glass conformed to Greek safety standards but did not conform to British safety standards. The claimant brought an action against the travel agent asking for a term to be implied as a matter of law, that all accommodation offered by the defendant should conform to British safety standards. The courts did not imply a term. Whilst this was a contract of a defined type, it was not reasonable for the travel agency to ensure that all accommodation offered, no matter where in the world, conformed with British safety standards. In summary, the courts are reluctant to imply terms into a contract. They will only do so where a term is prevalent in a trade, where it is necessary to give the contract business effect or obvious that both parties would agree to the term. In contracts of a defined type where the law generally provides protection, the courts might also imply a term, but only if it is reasonable to do so. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.elawrevision.org.uk for revision games and quizzes. Thanks for watching.